Before we get started, we wanted to let you know that hours after we recorded this podcast, the safe harbor deadline related to the Paycheck Protection Program was extended from May 7th and is now available through May 14th. So we just wanted to make that information clear as we do mention the Paycheck Protection Program and safe harbor during this episode. Now, please enjoy Let's Get Surety.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hi, everyone. It's Kat Shamapande. Thanks for joining us today. Today, we're going to be talking about some of the COVID-19 stimulus law, particularly the Paycheck Protection Program, or PPP, and some of the False Claims Act risks associated with that. Today, co-hosting with me, I have NASBP CEO Mark McCallum. Hey, Mark.
Hey, glad to be here, Kat.
Yeah, thanks for joining me. And I also have with me today as our guest, David Robbins, and he's a partner at Crowell & Mooring's Washington, D.C. office. And he's a member of the Government Contracts Group Steering Committee and a co-leader of the firm's False Claims Act practice. Hey, David.
Hi, thanks for having me.
Yeah, thanks for joining us. And I just wanted to let everyone know we are recording from our home studios today. So if the sound sounds a little different, that's why. And we're recording today on May 5th, just so you have some context, because this is such an ever-changing issue, isn't it?
Absolutely is. Guidance changes by the day and sometimes multiple times by the day. So no matter what you hear from us, it's always good to validate.
Well, let's start off today. I know the Congress has recently replenished the PPP with about $310 billion. Were there any other significant changes that came about in this round with this replenishment of the funds?
Well, there were a bunch of guidance that came out around the same time, including some guidance on what it means to have a need, what it means to have a necessity for these funds. There's a bunch of pushback in newspapers, political pushback, and you see it reflected in guidance about larger, perhaps publicly traded entities. You've seen some guidance, or at least some political pressure on private educational institutions with large endowments, really trying to zero in on what type of entities actually have a need for this money, and recognizing that this is an airplane that was being flown as it was being built, to use an old cliche, that perhaps the initial guidance wasn't exactly right. You have a safe harbor. The money can be returned within a matter of days from when we're recording, right? Just this week can be returned with a safe harbor in place and no future enforcement risk. Now, that may be right for some recipients of the funds. That's probably not right for the vast majority, but that's the other important wrinkle that we've seen.
In regards to the safe harbor, there's a timeline tied to that, right?
Yes, absolutely. It is basically having been deemed to have made a certification that we have a need for this money appropriately and accurately. So if the loan is paid in full within 2 days of our recording, by May 7th, will be deemed by the SBA to have made the certification of necessity in good faith. So that's a safe harbor in effect from False Statements Act liability, False Claims Act liability. And for anyone who is listening who might think, we thought the money was going to run out. We were told the money was going to run out. We talked to our financial institution. They said, we don't have time to go through this with you. Just apply, see if you get the money. Well, that's not really the way things work. If in the fullness of hindsight you're thinking we didn't really qualify, this is an important safe harbor for you. But otherwise, there are other angles of analysis that we should go through to reduce enforcement risk, audit risk, you name it.
Hey, David, do you think there's any effort underfoot to maybe extend that timeline beyond just a few days from now?
I don't know, Mark. I haven't really been following that. Have you heard anything that might suggest there'd be additional time?
I have heard some industries are thinking about making a request to extend it, perhaps maybe even for another week or so.
So let's just talk about this just a little bit. I get the concept of the safe harbor. I understand what it's designed to do. Oh my goodness, we really don't qualify. Let's give it back. But if we get to a position where it takes a little bit longer for recipients to realize, well, wait, we don't actually qualify, or to get their financial house in order, if they find a way to return the money in 2 weeks from now, yes, fine, they don't qualify for the safe harbor, but they are still proactively doing diligence, seeking to return money. It is still a risk mitigation technique. So whether or not this timeline extends, yes, there's increased risk, there's increased potential liability, but it's not like we fall off a cliff immediately. There's still time to get your house in order. And remember, we're just talking about the very highest risk, right? The access to tremendous amounts of capital, really push forward an application to make sure money didn't run out before they did any analysis. That sort of scenario is safe harbor worthy. The rest of it, there's more nuance. You might want to repay. You might want to take advantage of it, but there are also some other risk mitigation techniques, and I'm sure we'll get to that later, that are worth considering.
So, can you kind of articulate maybe a thought process that a company might go through to really think, I rushed into this, I wanted to get access to the funds, and now I'm having second thoughts. What are the exact things I should be thinking about and kind of making that analysis? And I probably shouldn't be doing it alone, perhaps be doing that analysis with counsel.
Thank you. Yeah, that's exactly the right way to attack this. First and foremost, anytime you have that feeling, I might not have complied, or I'm having second thoughts, you'll want to shield the analysis under privilege. That doesn't mean it's a secret to getting away with anything. That's not the purpose, but that's to enable candid conversations and an assessment of strategy. You have to have legal counsel for that. Privilege doesn't exist with other communications. And what you want to go through, and this is the most important thing, you want to look at the timeline that the guidance came out and when you applied. If you have a credible reason to need the money according to the guidance at the date you made your certification, I certify I have a need for this money given the impacts of COVID-19, right? To paraphrase the certification. If that was reasonable at the time, well, you might want to talk with your counsel about ways to document your decision process at the time. Or if you didn't do any of this analysis, you can always look back and say the day you applied, this was the guidance. Do you qualify or do you not? And if you qualify, or if there's a reasonable basis to believe you qualify, memorialize that analysis. Because we already know any loan above $2 million will be audited. Full stop. That's already been announced. And there's still going to be audit risk for dollars under $2 million. And anytime there's an audit, there's potential for enforcement risk, including False Claims Act and other enforcement from the government or other whistleblower risk. That you have something in real time or near real time that gives you a nearly contemporaneous analysis of the thinking and whether you qualify, it's a lot more powerful going forward. And look, the flip side of this coin is if you're not able to demonstrate necessity, that's when you start reaching back out to the government, explaining why you applied the way you did and wanting to give the money back. This is a refrain we're hearing a lot. And I'm sorry, Mark, this is a long answer to a really good short question, but I'll wrap it up real soon. We're hearing this a lot. You know what? We reached out to our financial institution. They, by the way, have liability protection, some immunity through this process for letting the money. They perhaps didn't have a lot of time to give us guidance because they were dealing with a crush of applicants, and they just said, apply and see what happens. Well, that's not a great explanation. It makes sense in the moment, but that's not a great explanation many years from now or many months from now when enforcement or audits begin. So that's the scenario where you really want to document. And if appropriate, you really want to think about giving back the money. By Thursday, great if you can do it. But even if you can't, getting there before the government gets to you is not the end of the world. Giving the money back while they can still redeploy it across the economy to more appropriate recipients, also not the end of the world. And I know that's what's being lost in the dialogue right now. There's a lot of alarmist discussion right now. But we want to make sure we don't lose track that just because the safe harbor provision ends, you're out of luck. That's not the case. You still have options.
That's a great point.
David, you touched on the importance of having discussions with legal counsel. Clearly, a number of these companies probably have an informal group of advisors that go beyond their legal counsel. Perhaps they maybe, have a bond producer, an accountant, and others. How careful do they need to be in having those discussions? And what would be the appropriate use of those other consultants?
The other consultants are really helpful, right? You need your accountant to understand the finances. You need your accountant to understand whether you qualify under the appropriate ratios or equations for PPP. Your bond producer is a really important conduit to your surety. And the financial health of the business is going to be vitally important to surety companies, whether you're drawing on a bank line, for example, as opposed to taking advantage of PPP, can impact the amount of bonding that you receive. So those communications are really important. Where we get into trouble is where we go beyond, hey, how does this impact our analysis? What are you thinking? And start communicating, we don't really qualify, but what if? Right? Nobody should be communicating that way. One, because if you don't really qualify, you shouldn't be taking the money and you should be giving it back, full stop. But those sorts of communications, especially when it's not just you and your lawyer for the purpose of seeking advice on how to give the money back or whether you should, it's not privileged. The government can get their hands on them. And we've seen time and time again, especially in recent years, the surety industry and the contractors who go beyond the pale, at least in government contracting, and violate rules or don't take advantage of set-aside contracting the right way, all of them are lumped in for purposes of enforcement actions, and they all have liability to the government. So it's an area where enforcement action is present, and people think broadly, maybe not to the accountants yet, but certainly to producers and surety companies. So this is just an area we all need to be conscious of being on the up and up, and making sure we understand the guidance at place at the time we made our certifications and are going about things the right way. Everyone has an important role to play in getting it right. What we don't want to do is start talking about, well, we probably don't get it right, but what if we paper over the record by? That's a conversation no one should ever have because it's wrong, first and foremost, and it's dangerous, secondly.
So once you've gone through the analysis and determined that it probably was appropriate to take that money, I'm sure now you have to think about, am I using it in the way that it's intended to be used? So for example, that you can't kind of use it in other purposes beyond what guidance has been given. Could you tell us a little bit more about that, David?
Sure, and I can give you a sense of ways to be able to demonstrate that the funds were used the right way. I am not as skilled as some of my other colleagues in the firm who have been watching really closely how the funds can be used on a day-to-day basis. That's more for the corporate department. I'm a lot more of an enforcement defense lawyer. So I just want to share that to note. You'll want to make sure you pay attention to the loan documents and the statute carefully and use things the right way. Take the money the right way. I would suggest, we all suggest in this firm, a separate account for the money, tracing the money, how it's spent, keeping good, solid records, because people will come and ask questions about how the funds were used, and you need to be able to demonstrate they were used appropriately, both for the ultimate audit and to make the decision later whether or not to seek forgiveness of the loan and how. So an audit trail is really very, very important here to be able to satisfy everybody. And if I can go off topic for just a second, because it's a theme I think we're going to come back to later, this repeats itself. I know this is unprecedented. It's called the novel coronavirus. It's new, it's novel, it's never been seen before. But if you follow natural disasters, economic bailouts, overseas war zone spend, as I do in my career, this follows the same exact pattern. There's a lot of push to get money out to those who need it, to recover from the disaster, to get whatever it is moving, to establish military bases overseas, you name it. There is a lot of waste in the effort to get things rolling. And then the government realized, you know what, we can do things a little bit differently now that the crisis is over, or we have a better sense of how programs are being taken advantage of. Then you see more guidance, and then you see audits, and then you see enforcement, right? The risk and what has caused, I've been involved in many civil and criminal defense efforts after these things. The risk is that you don't take advantage of this period now to keep good records, to explain what you did. Everyone knows right now in the press of this moment, as we're all stuck in our homes having trouble getting cleaning solutions and groceries and sending our kids to school, right? Everyone knows how crazy this is. When audits and investigations begin, I really hope this is nothing but a distant memory, and that understanding will fade. Your contemporaneous documentation lives on. That's your best defense.
That's a great point, that even though this is new, we've been through other things that give us guidance on what will happen.
So, David, is the government short on resources for enforcement?
Are they short? No. The statute themselves appropriated tens of millions of dollars to enforcement, and they have created multiple levels of enforcement with a special inspector general whose hearing is actually today for confirmation, and I hope he gets there. He's an old friend of mine. He'll be very good in the role, aggressive as he needs to be and fair as he should be. There's a committee of inspectors general who will be using all their resources to go after improper use of these funds. The Department of Justice has decided what its enforcement landscape will be, and state attorneys general are all lined up to take care of what needs to be taken care of. There will be plenty of enforcement opportunities and mechanisms. The closest analog I have is Hurricanes Katrina and Rita, and depending on the age of your population, that might not mean much to some of your newer entrants, but they came through, decimated the Gulf Coast. The recovery was 1/20th the size of this, and there were still 500 or so auditors evaluating thousands and thousands of contracts, with many, many, many hundreds of investigations and prosecutions in the 12 months following the storm making landfall. And that was 1/20th the size of this. So there will not be any dearth of resources to pursue enforcement action where they are warranted. I do think, though, if I could go beyond the question in 15 seconds or less, I do think, though, that this should not terrify people. People should be on guard and appropriately concerned about documenting their decisions and explaining them, because they can expect questions. But what they shouldn't be fearful of is expecting a criminal prosecution or a civil enforcement case. If you document your understanding, you seek appropriate external guidance, and you go about things the right way, there still is room for, yes, we can disagree with the government later, but it doesn't make it an enforcement event. Where you really have a little bit more trouble is if you get so caught up in the crush of the moment, you don't do any analysis, and you're trying to justify it months or years after the fact when recollections and documents have faded.
Well, I think that's great to get some lessons learned from past experiences. Are there any lessons that we should take, even just from the first round of the deployment of funds?
It's a really good question. I'm pausing because I want to do it justice.
Okay.
I think the lessons, and I'm not sure how applicable this will be given the timeline, but the lessons are: take a breath, make sure you qualify, keep some records as to how. And I think the second bit is just, again, with the take a breath line, take a deep breath, relax a little bit, right? This money is here to get liquidity to American businesses, to keep people employed. A lot of what we hear about from clients is, without these funds, we would have had to lay off staff, right? Because the entire economic environment is so uncertain.
Yeah.
That's a really good indicator that these funds are being used the right way. The government's actually trying really hard to do the right thing and keep the economy moving. Let's not get too wound around the axle about enforcement risk. Anytime you take government money, there is enforcement risk. I get that innately. It's part and parcel of what I do for a living and defend those things. But just because you take government money doesn't mean you're going to have to pay the proverbial piper later.
not to keep harping on the enforcement risk, but in terms of the length of time in which they can audit, is there a particular length of time that people need to be cognizant about?
I am sure there is in the statute. I can't say I've taken a look at that closely to know. I do know the statute of limitations for the number one fraud recovery, civil fraud recovery statute, the False Claims Act, is 6 years. It can be extended to 10 if there's some sort of conspiracy count out there. Ultimately, the length of time is long, but I think we can be told and take comfort in what we're told that the SBA, Small Business Administration, plans to audit all loans over $2 million. I think that's months to years, right? I'm not sure it's going to go on for too terribly long. So I think the lesson is keep your documents, stick them, quarantine them, you use the wrong word, right? Stick them in a filing cabinet, figurative or literal. Make sure they stay, because you never know when these questions might come, either from the government or an opportunistic plaintiff trying to seek a portion of recovery. These things can happen, but your best defense is having good contemporaneous documentation. And it doesn't hurt to be totally self-serving, to also know how to find a good lawyer once in a while.
That sounds great.
Well, David, so while we have you, what would be the right way to go and find that lawyer? I mean, what should a person look for in somebody who's going to be a knowledgeable counsel in this regard?
I think there are three categories, and I take the question as it's intended. I'm trying to do this objectively. You call me great. You don't call me also fine. I want to make sure the listeners are armed with what to look for. First and foremost, familiarity with government contracts and grants. And I say this because there is an innate understanding of what happens when you take government funds and you participate in a regulated industry and what the rules are for the way you count affiliates, for the way you count size, for the way you understand eligibility, that comes with that foundational knowledge that others probably need to try to bolt on later. And it's hard, and you got to be able to get it right. In your industry, an understanding of the role of surety players, whether it's the producers, the surety company, underlying contractors, the types of communication that they have back and forth, to understand where these communications can be misperceived by the government. We're in the business of understanding financial risk. We're in the business of explaining financial risk and why an entity is a solid underwriting decision. That is at cross purposes sometimes with the government's approach that what small businesses is and should be able to do on their own. And I've seen time and time again in False Claims Act defenses that we handle the way those normal methods of communicating can be misunderstood on both sides. So papering the record, papering your understanding in the right way, and avoiding the possibility of it being misunderstood later, it's important. So you need government contracts capability, you need surety industry knowledge, and you need an understanding of the enforcement environment. Who's going to come looking and when and what their communication path is. Is an audit just an audit? Or is an audit a precursor to an enforcement action? And how do you calm down those stakeholders so they think, you know what, they're doing things right? Or yeah, this was a little gray, but their analysis was okay in the moment. There's no need to escalate. Those are the three buckets of capability I think you need. I don't know that there are an awful lot of lawyers out there who have those three, but I know there's a small handful of us. So that's what I would look for were I in your listeners' shoes.
Thanks. Not any lawyer will do, and that's great information.
Yeah.
Thanks so much.
Yeah, thanks, David. Thanks for joining us today. And for anyone who's listening and wants more information on this topic, David is presenting an NASBP virtual seminar, which you can listen to live on May 6th or listen to the recording at any time. So you can tune into that to get additional information. Thanks so much for joining us today, David.
Really appreciate being invited. Stay healthy, stay safe, and be well, everybody.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.